Record should reflect all parties are connected by Zoom video. Mr. Vernon, this is another hearing on this issue related to the sale of the marital home and the federal lien that apparently is on that home. Can you tell me where things are at from your side at this time?
Yes, we've had I and my office have had several conversations with the Olivia Brooke from the Attorney General's office, and it is clear to me that the proceeds from the sale of the home have to be divided between Sherry and Robert, essentially without any attachments or any other considerations. So that it simply it has to be he gets half, she gets half, or she gets what she paid in, and then his half. And his half would go to the settlement of the lien that's on his federal criminal restitution lien. So I've been having conversations with Mr. Gray regarding the way to create that language and draft that sufficient to address all of the parties' concerns. We have not reached an agreement on that matter. So we're still asking the court to set aside the consent judgment because that consent judgment is based on the parties selling the home and then using those proceeds to pay off debts, and then using those proceeds that they would each be entitled to pay the other for certain pieces of property. Mr. Gray wouldn't have any of that money because it would all be assumed under the lien and go to the federal government. So he's not in a position to pay those expenses that are under the mediation agreement. And we can't satisfy the first sentence of the mediation agreement of the settlement part says that the first be applied to mortgage obligations, then the proceeds of sale will be secondly applied to the Visa credit card balance. Well, that part can't be done. I mean, you can't apply it to the Visa credit card balance because the Attorney General is going to object to any portion of the money that is awarded to Mr. Gray goes to them. I mean, that's their money. So we can't use the proceeds of the sale of the home to do that. Money has to be divided first, and then that money goes to the government, and then the assets and the division of property can occur after that, essentially. So what we have proposed, we drafted several different proposed consent judgments that identify essentially Mrs. Gray getting what she paid into the home originally, the $78,000 that she paid into the home, or $72,000 that she paid into the home, plus some additional money for things that have already been sold by Mr. Gray. That's her portion. And then because Mr. Gray doesn't have any cash with which to pay for the things that the mediation agreement was suggested, would be that he would let her have side by side, which has debt on it, but has probably some equity, and she could sell that, pay off the debt on it, and then recoup some of her expenses through that. Mr. Gray reviewed that. We sent it to him on the 8th. He sent back several emails to me in my office suggesting that he would not accept that. So our position is the same. The mediation agreement and the consent judgment cannot be satisfied as they're written, and the consent judgment needs to be set aside essentially for either fraud or mutual mistake. I mean, either way, the parties can't satisfy this, and Mrs. Gray had was not aware of the lien when she entered into this agreement. Now, if Mr. Gray also did not know, then it's a mutual mistake, and that's grounds for setting it aside. If he did know, then it's fraud. So one way or the other, there's grounds to set this aside. The reality is the contract can't be performed due to that information. And so we basically have to come to a new agreement, but that has to start with setting aside the original one. And that's what we're asking the court to do.
All right, thank you. Mr. Gray, what's your side of this?
Well, none of that is really true. So if we back up to the original, the first, I think it was the second from last court date in your jurisdiction when we found out about the lien. There was a deal in place.
Let me just, I just want to stop you for a second. You said none of what he said was true. So tell me what parts of what he said is not true.
Okay, the part about him sending me agreement, I sent them 4 proposals in the last 2 weeks. They never replied to any of them. And they sent me a vague proposal on the 8th with the same amount that I sent to them in my proposal. Mine explained where the money would go. Theirs was vague. So I turned around and I sent them a message yesterday. What happens with the side-by-side? Because the side-by-side has a lien on it, and no one would give me an answer. So I can't sign nothing. I tried to negotiate with them. I know he's a busy man. I get it. But I've been trying to negotiate with them to get this resolved. I went as far as giving her, here's the original problem, Your Honor. They'll never say it, but I was awarded $23,000 in this case towards the money that was put down on the house, the $72,350. Your court honored or gave me $23,000. From that day, they never will say that I had $23,000. So she thinks that when we had the agreement set aside, that was $85,350 with all the attachments to it. Him and her are taking I don't know how you would say it, but the stance that was her money. Only $62,350, that money was hers. $23,000 was mine, and I gave it back to her so she could pay half of the credit card and pay off the side-by-side. That's what that deal was. And in that but obviously it changed when they made the agreement and the government seen it and said, no, you can't do that. And I said, no, they can't do that because she told us we couldn't do that. The money, I could set money aside for Sherry, we had to have receipts, and then the rest of the money was split. Well, when they added the credit card and the side-by-side in the the real property part, or whatever that paragraph is, I knew it was gonna work. It wasn't gonna work, and it hasn't to this day. And to this day, we've talked, negotiated, and they will never admit where my $23,000 is. So with that being said, this is what I came up with, Your Honor. I would let her have all the $72,000 she put down in the house. I produced receipts that the government accepted for $1,500 on the four-wheeler, $1,500 on the storage container, and $12,000 for the Kabota, which she would get half. So that came out to $79,800. I said she keeps $62,350, which she was allotted. She can pay half of my credit card or our credit card for $5,500. Then she could apply the rest of it to the side-by-side, and that within 30 days of closing on the house, I would pay the side-by-side off. Everything's done. They didn't like that. Well, they never said nothing. They never said nothing. So then I came up with another one. I'll give you $79,800, $62,350 is yours, $55 for the credit card, and then take the $12,500 and split it amongst my 2 kids. She got mad about that, but that's not in writing, but that's fine. We argued about it. And then I came up with another one. Just give her the $79,800 and she gets her $62,250, and then she can do whatever she wants with the money. If she don't want to give it to my kids or our kids, that's fine. If she doesn't want to pay the credit card, that's fine. All I asked for was, what are we going to do with the side-by-side? I put $10,000 of my own money on that side-by-side. So me and her never discussed, or Mr. Vernon, about taking that side-by-side and selling it so she could pay bills. That was never discussed. No one ever asked me, and I would not agree to it. What I was going to ask was, since I changed my stance, gave her all the money, let me buy the side-by-side for what's owed on it. That's all I asked. So that's what I'm saying. None of that stuff's true. We never talked about the side-by-side selling it. But if you even ask them today, they still won't admit that $23,000 is my money. They won't mention it. But where is my $23,000? Whether I get it or not, or the government gets it. Oh, that's another thing here too, Honor, I got to be honest. One of my agreements was, I said, she gets her $62,350 out of the $85,000, or no, it was $79,800, or the government can have the rest, because I'm not giving it to her. It was never hers. It's my money. Either she pays half the credit card, give it to my kids, or pays for the side-by-side, or it goes to the government. That was my stance, because the way she treated me and all this, which is my business, I wasn't giving it to her, because it's not her money. It's my money. I was awarded it. That's where I'm at, Your Honor.
Okay, all right, thank you. Mr. Vernon, it's your motion, anything in response?
So the $23,000 he's talking about is the mediation agreement states, fourthly, payment would be made to Robert in the amount of $23,000, period. Finally, any remaining balance will be split between the parties. So where he says that's his money, I'm not sure, I'm not sure where that comes from. That's simply part of the agreement that as a disposition of the proceeds from the sale of the home, he would be awarded that portion.
No.
So the problem with that is that the agreement says that they would sell the Kabota, the storage container, and split the proceeds equally. Well, he sold the storage unit, the storage container and the Kabota to a friend of his at a very reduced price without an agreed upon price from my client, and my client hasn't seen any of that money. He has not paid her the $2,500 that he was supposed to pursuant to the agreement. He has not paid her the $1,250 that he was supposed to pay her to the agreement pursuant to the four-wheeler. And he has not, right. And then the Kabota was the thing, again, they didn't get a fair market value on the Kabota. He simply sold it to a buddy of his to his uncle for $12,000 on a piece of equipment that would have likely sold for twice that.
Yeah, right.
The $23,000 is subsumed into those.
No.
What I guess I would say those unethical will be the word I will use. Sales and actions by Mr. Gray. So I think that the proposal that we have, again, I'm not suggesting that you're going to be in a position to negotiate or reach an agreement for us. What I'm suggesting is that all of the things that were agreed upon in the mediation agreement cannot be satisfied. The storage unit's already been, or the storage unit's been sold, the Kabota's been sold, no fair market value was ever assessed to them. The Visa credit card bill can't be paid the way it's intended out of the mediation agreement. So, I mean, if the court doesn't set aside the mediation agreement or set aside the consent judgment, then we have to turn around and immediately file some sort of breach of contract or show cause on this because he can't satisfy those terms. I just think it makes more sense to set this aside. Let's work with the Attorney General and the Realtor to get the numbers where they need to be and then go forward.
I have a lot to say, Your Honor.
Well, I'm not gonna, Mr. Vernon's right. Like, I'm not here to negotiate for you guys at this point.
But can I say one thing?
Let me finish saying what I'm,
okay.
Let me just saying what I'm gonna say and then I'll give you a chance. My only decision today is we have a consent judgment that was entered into by both of you. You both agreed to that was missing an essential item, which is that there's a federal lien on your home that affects how and whether or not that judgment that everybody signed can go forward. And that's a really important and substantial factor here. And so, you know, unless what you're going to tell me is going to relate to why that lien wasn't brought up as part of negotiations or what effect that lien has, I'm not sure. You know, it sounds like you just want to complain about the negotiation.
No, I don't want to negotiate, Your Honor. I've tried to negotiate. What I'm going to tell you is that we had a court hearing from your court, and it's in the divorce agreement about this federal lien. Everybody knew it. The only thing that screwed up that federal lien was what he did when he put the credit card and the side-by-side in the real property when he knew it wasn't supposed to go in there. That's why I got the court transcripts from the court, and I knew it was he's wrong. And another thing is, my $23,000 never came out of the house money. It was out of the $85,000 because I was awarded $23,000 out of the $72,000 that she put down on the house. Go back in the court records. It was $72,300 she put down on the house. You awarded me $23,000, Your Honor, of that money. That's where the $23,000 come from.
You guys, I didn't award anything. You guys are the ones that
okay. Okay. We have a signed divorce decree. So that goes back to another thing. Hold on, please. One more thing, Your Honor. They keep on saying, I sold this stuff, I sold this stuff. We've been divorced since April 4th. Look at the receipts on when I sold everything after the divorce, Your Honor. We're divorced. I've sold it, but I gave her fair market for over fair market. I had to sell it because I didn't have a job. But I never told her she wasn't getting the money. She's still getting the same. She's getting the exact same amount of money right now from the day we filed the divorce, which was final, to she's getting now. She was never getting more than $62,350. That's the whole point. She was never getting more than that. She was only getting on the $72,300 she put down the house minus my $23,000. Then you add in the stuff I gave her for the side-by-side, I mean, for the four-wheeler, for the storage container, for her lawyer, half of my truck. That's where the money came from. She was never getting any more than $62,000. She's getting that now. I got the court transcripts from our court dates. She was never getting what she's getting, the exact same amount. The only difference is she wasted 9 months of paying house payments on a house to go after the exact same thing she was already awarded. Now they want to open this all up and let's go waste all this time. It doesn't make no sense. I'm giving her everything she wants. She's getting the money again. She's getting her money for $62,350. She's getting money for a credit card, and I just gave her $12,500. That was my money. I don't understand why can't we just end this right now? And one more thing, Your Honor, you can call Olivia yourself. She will not negotiate with anybody. That's not their job. So this is just a waste of time. I'm giving her money and more, but it's your court, Your Honor. You do whatever you want to do. I understand.
All right. In my view, we've got a problem with this consent judgment that was entered into by the parties that's going to prevent either side from performing their obligations under that agreement. And I don't think it's an issue of fraud. I don't think it's an issue of mutual mistake. I'm looking at this as pure impossibility. It's just not going to be able to be accomplished in the way that both sides contemplated it, and in the way that it's set forth in black and white in the consent judgment of divorce. So the last thing I want to do is open up a case that I thought was closed to. Takes up time on my docket. It causes delays for both of you, and I get that. This is not it's not an ideal situation for anybody involved. So I don't do this lightly, but I just don't see that there's any way that either side can perform their obligations under the consent judgment of divorce as it was entered into because of this lien issue. So for those reasons, the court is going to grant the motion, the court's going to set aside the consent judgment. The court is going to order that the parties go back to mediation. The court's going to order that occur within the next 60 days. And the court will set this for a status conference at the close of that period of time. Mr. Vernon, you're free to continue to engage in discussions with Mr. Gray. It sounds like he has submitted some proposals to you guys. So to the extent that you haven't responded to that, I think this is only going to work if both sides are communicating back and forth. And we'll see where we're at. If the parties are able to reach an agreement, then we can go forward at that time. If they're not, then the court will set this for an evidentiary hearing. The court will take evidence and testimony about all the remaining issues, and the court will make decisions to get this resolved. So, Mr. Vernon, if you can prepare an order that reflects that ruling in the court today and submit that on the 7th day rule.
Do you want me to submit that? Do you want the just that the mediation or that the consent judgment set aside, or do you want me to include the mediation to occur within 60 days in that order as well?
Yes, please.
Okay.
All right. Thank you. That's all I have for today. All parties are free to disconnect at this time.
Thanks, Judge.
Thank you.